What I really need from my law firm is someone who can provide my staff training so we actually can stay out of trouble.
I really just want somebody who's going to aggressively fight for me in court. Is that too much to ask?
When you have property management problems, we have your solutions. This is the Zona Law Group podcast with the experienced attorneys from Zona Law.
And welcome back to the Zona Law podcast. I am Mark Zinman. I'm joined here by Chris Welch. How you doing, Chris?
I'm doing good.
Good. For all the viewers that have seen this before, we have officially lost our headphones, we have lost our jackets, and we're going as casual as we can be. Well, casual as lawyers can go. We're still dressed up in ties. Today is going to be an exciting day because we are starting off a new series in fair housing. We're going to do a 5-part series on the most important things for fair housing. And, of course, with part 1 of the series, we go for the most difficult, or the ones that I should say that we hear the most, which would be what?
It's questions involving assistive animals. And frankly, like Mark said, this is the one that we hear the most. We get emails and calls multiple times a week related to, hey, I have an applicant or a tenant that has an animal. We don't allow animals. What do I do? And frankly, it's a complicated issue, but we will do our best to walk you through it.
Yeah, and it seems that something that managers really do get confused on a lot, even people that have been in it for years, because things have been changing, and there's always an extra nuance, an extra layer that you have to the issue. So we'll go through it all and kind of walk you through the basics of it. For years, obviously, what it comes from, if people don't realize, is in 1988, disability became a protected class, just like race, color, religion, national origin, all of those. And as part of disability, you have to grant accommodations, modifications. Accommodation would be change in policy procedure. And that's all an assistance animal is, right? You view it in that context.
Yeah, it's essentially, like I said, you could have a no pet policy. That's the policy. But with disability being a protected class, there may be a situation, and frankly, lots of situations where an animal would be required. And so you'd have to adjust your policy to allow that resident to have their animal.
Yeah, and people don't realize that it's a reasonable accommodation, but it's actually the most common one we deal with. And so this has been litigated for years. We've been advising clients for years. And every couple of years, HUD has come out with a memo kind of giving nuance and updated information. Most recently was in 2020. They came out with a pretty comprehensive memo addressing assistance animals. What can you tell us, kind of the big overview of what it came out in 2020?
Yeah, so one of the changes, like you said, they've given prior memos, they've given us information in the past, but here they've essentially created a list of questions, even in a flowchart manner, that allows you to go through, okay, is this a ADA applicable? Is this, which law applies and what you need to do? We're not going to go through each of those questions.
You don't want to be bored with the flowchart questions.
Yeah, it can get pretty in depth. So
yeah, I think the best way to look at this is, a client comes to me and says, hey, I've got this sheet. Somebody's saying that they need this assistance animal. I don't see any obvious disability. Do I have to actually approve them? What do I do? Can I just reject the animal? Maybe I think they're abusing it. And so let's step back, because there's a lot of confusion here. What you have to realize is there's a bunch of different terms, right? You hear the term service animal, assistance animal, emotional support animal, and then some of them come from different areas. Service animals, for example, comes under the ADA, which applies in certain cases. Emotional support animals only under fair housing. All of them, though, for managers of property, you have to realize we are dealing with the overarching term assistance animals. That covers emotional support animals, service animals, anything. Fair housing is the most generalized term, correct?
Yes.
I mean, there's, for example, service animals, like I mentioned, it would be just dogs or potentially miniature horses as well. Don't get confused in the nuances. You as an on-site manager have to assume that you're under fair housing and that it is the most broadly defined term. So what usually happens, like I mentioned, somebody will come in, let's say we say certificates. So how do you analyze a certificate?
Yeah, so a certificate could be something as simple as something that you printed out online that has a picture of a dog on it that says this dog is a certified support animal or something to that effect.
And does that qualify?
Most of the time that would not qualify because it's in relation to the dog and it's not signed by a healthcare provider or prescribed by any legitimate source.
Yeah, and there's a lot of information in there, and that's the critical part of what happens here. Under Fair Housing Act, you're allowed to seek verification that the person is disabled and that they need the animal for the reasonable use and enjoyment of the property. Now, think about it back to what Chris is saying, is if somebody comes in with just a certificate, most of those certificates are signed by like a chairman of the board or the CEO, and like Chris said, it says that the dog is registered. It doesn't mention anything at all about the person being disabled, and therefore you're missing the first prong entirely. And the HUD memo actually addressed that, saying most of those are not going to be qualified because they're not going to meet the factors that you need to. What happens though if somebody goes online to like a e-visit or a remote doctor, and then you get a letter from the doctor?
Yeah, those could very well qualify, because essentially what we're looking at is there's a disability and then there's a need for the animal. As long as the note from the doctor establishes that, and the doctor is saying, this is my patient, there is a disability, and they have a need for the animal, then that would satisfy the requirements of fair housing.
Yeah, and we understand a lot of times if you see your patient, your applicant, or your resident has been living in Arizona for 6 years, and suddenly they're bringing you a doctor's note, and the doctor's from Colorado, yeah, there's some questions there, but now with remote telemedicine, that is the world that we live in. You can't assume that it's a scam. Like I mentioned before, you have to come into each one of them and look at what is being provided. And in this case, if somebody gives you a note from a doctor, that qualifies. Now, I always look at it as it's a prescription the doctor can give, right? The doctor's saying this person needs this, and they're disabled, and therefore that they're getting that. What if the doctor's note is 5 years old?
Yeah, so if the doctor's note is 5 years old, again, these are all fact specific. So if you have any questions, talk to your supervisors, call your attorneys. We're happy to discuss it with you. But yeah, 5 years old is beyond, in my opinion, is beyond what I would deem is acceptable.
Yeah, and Chris's point is great. There's no bright line rule, and that's why when we're advising clients, it's hard because we're walking through these things with you, but there is no just, yes, this is acceptable, no, it's not. I mean, I think within usually a year is a reasonable prescription period for a doctor. Going beyond that, you've had a note 5 years ago, you can ask for an updated information because it's possible, depending on what the disability is, the person's not even disabled anymore. What's important to realize as well, you can only ask for that information for a doctor's note if the disability itself is not obvious. So if a person comes in, they're blind, they need a seeing eye dog, would you ask them for a medical note?
No, I would not.
Yeah.
And it's an obvious disability. You can get into the weeds here a little bit, but if someone has epilepsy and has a seizure alert dog, that normally is not a visible disability. It's a serious disability where they're obviously going to need the animal, but in that situation, I think requesting confirmation would be appropriate. But the seeing eye dog, someone in a wheelchair, other obvious disabilities is something that you wouldn't need to request any additional info.
Yeah, and actually, it's just funny that you mentioned wheelchair as well, because that's actually how, whenever a client calls me, that's what's going on in the back of my head. When people always complain about the abuses in this area, but I always think of an assistance animal as a wheelchair, which is, okay, the person needs it, and the doctor's saying they need it for the reasonable use and enjoyment of the property. So the obvious questions are, can you charge a pet fee for that assistance animal?
No, you shouldn't charge pet fees. You shouldn't charge normal pet rent, ongoing monthly. Those fees and charges would not be applicable because, like Mark said, you kind of consider it more as, it's considered legally more as a tool, not as a pet. So like a wheelchair or a walker, you wouldn't charge extra for as a wheelchair fee, and so the same you wouldn't charge for an assistive animal.
Yeah, and if there was any questions about that, let's be clear. Do not ever charge somebody for being in a wheelchair. That is clearly a violation of fair housing. And it's the same
Yes.
with assistance animal as well. Even just simply saying, no, we don't allow assistance animals, that can get you in trouble. Even if you're in a no pets property, the fair housing laws will trump, and you have to allow those. And it's, remember, do not get confused about service animals, emotional support animals, assistance animals. all of them fall under the rubric of assistance animals, which is covered by fair housing. For example, Arizona and another number of other states have penalties. I think it's $250 in the state of Arizona for providing fake documentation about a service animal. Okay, well, service animal in that context is referring to the ADA. If you even threaten that potentially under the Fair Housing Act, I think that's a potential violation. So you don't want to go down that road. I do want to step back, though. You said you can't have pet fees, you can't have pet deposit. What happens if the animal causes damage while the person's in the unit? Can you charge the tenant for that?
Yeah, the damage is still appropriately charged out at the end of the lease. Once you have once you've got possession back, you make an assessment of the damages done to the property, and you don't need to say, oh well, there's damage from the dog chewing on the baseboards or something. It doesn't matter whether it was an assistive animal or a pet.
Or even the tenant
that's
sometimes.
Damage, yeah. The tenant's down there messing with it. The damages done are still applicable.
Yeah, and that's what it comes down to, because the tenant, and that's the reason it's not discriminatory. On the front side, if you charge a pet fee to an assistance animal, you're assuming what they're going to do and the damage they're going to do, and that is a form of discrimination, where after the tenant's moved out, if the tenant has not returned the unit in the same condition you gave it to them in, you can charge them for that. You don't care if the dog eats the baseboard, if the tenant eats the baseboard. The reality is there's damage to the baseboard. And the tenant's ability to avoid that is just simply making the repairs before they leave. And then you don't charge that against them. You just don't do that during the term of the lease either. Similarly, what happens if you have an assistance animal that bites another person on property?
Yeah, so that's a big conundrum that we run into a lot. People say, "Oh, well, it's my service animal or it's my assistive animal. You can't do anything about it." But the law requires that it be reasonable for you to allow an assistive animal to reside, to allow the resident to use and enjoy the dwelling. It's not reasonable to allow a known aggressive or dangerous animal to remain at the property. So if you have a dog bite on another animal or on another resident, a lot of the time that would require a legal notice be delivered and requiring that the animal at least be removed.
Yeah, and in that case, if the dog bites somebody, the person can get another assistance animal. The reason is this isn't even a fair housing issue so much. It's a premises liability issue in Arizona, which is landlords aren't liable for the acts of tenants' dogs on property. But if you know that animal is aggressive, for example, it bites somebody, and you let the dog stay, if it bites somebody else, the landlord's going to get sued that second time around. And it doesn't matter if it's an assistance animal. It's just simply the liability that's created, and therefore it's no longer reasonable to allow that specific animal to be on property. Now, we've talked a lot about dogs, but there are other types of assistance animals, right?
Yes.
What have you seen?
Like you mentioned, a miniature horse or a dog is acceptable under the ADA, but in fair housing, they call them unique animals. Some of the most unique that I've seen, turkeys, chickens, and snakes. And personally, I'm not a huge fan of snakes, but if it provides you with emotional support or a doctor prescribes it, then that could be something that you would have to allow. But in those unique situations, the burden shifts a little bit, and the tenant is required to establish the need for this unique animal. Like, why can't they just use a dog or a cat? Why do they have to have this more exotic animal?
Yeah, because if you think about it, you have the standard, what they would call, under the HUD memo in 2020, refers to your household animals, which would be your cat, your dog, and then it refers to the unique ones, like Chris is saying. And if a tenant brings a unique one, they really have to justify that at a higher burden, why that is necessary as opposed to a dog. And the one that I always think of is there's an example of somebody having a monkey, which if you haven't been in this industry long enough, you wouldn't even think that's a possibility, but it is under the Fair Housing Act. And a reason somebody may need a monkey, for example, is if they're allergic to dogs and the monkey can actually be trained to provide a service or actually do something, it's possible that may be a better assistance animal or service animal. Again, we're thinking big bubble here, that's better than the other alternative of just a dog for that person. So there's a reason you may have to allow it. But again, if you always come back to the beginning is the person's going to come in and say, I need to have this animal. And the question is, what do you do at that point? The best thing you can do right off the bat is, of course, we comply with fair housing and give them the reasonable accommodation form, or if you have a form specific to pets as well. Correct?
Yes, and you can't require that they utilize a specific form. If they say, no, I've got a doctor that wants to just provide a prescription note or something like that, that could be sufficient. But like Mark is saying, that's a great starting point. Someone comes in and makes a request but doesn't have the paperwork, you can hand that to them, the reasonable accommodation form, and we have those available that you can request, and again, like I said, make sure that you're not requiring a specific form if you get the information that you need in another way, but that's a good starting point.
Yeah, and that is a critical point, and I'm really glad you said it, because we see it all too often, and it makes sense. If you think about it as a prescription, no different than a drug for the patient, and who is obviously your tenant, the doctor can write on their own prescription notepad saying, this person is disabled, they need this dog to reasonably use and enjoy your property. And again, that hits the factors of what's required under the Fair Housing Act, so you would accept it. You can't reject it just simply because it's not on your form. And more often, we're seeing it's just simply doctors are writing letters to account for that. So I think that the most important thing is any preconceived notion you have to look each case on a fact-by-fact basis as to whether they're reaching the elements. And if you need any forms, you're welcome to contact us at Zona Law. We can give you forms. For example, the last 3 pages of HUD's memo in 2020 is actually a guidance given that you can give to the doctor as well for what information that they need to provide in their letter.
Yeah, because there is still confusion out there. We don't need information that would violate HIPAA or other medical privacy laws. We essentially need to know if there's a disability, and then if there's a need for the animal. And some healthcare providers get confused and say, well, I'm not allowed to provide any of this information. And so that the last 3 pages of the HUD memo explaining that is helpful if you're running into an issue like that.
Yeah, and we'll talk about that more as well under other part of this 5-part series about accommodations. Under the Fair Housing Act, you're not allowed to ask to the nature and extent of the disability, right? So you're not going to ask, oh, well, you look fine, so tell me about your disability. That's a problem. You're just seeking from that doctor to confirm this person is disabled and they need whatever the accommodation is, which of course here is assistance animals. But we'll delve into that in another podcast. And until then, we look forward to seeing you at the Zona Law Podcast.